Welcome everyone to this special event marking the 1-year anniversary this month of the late Justice Antonin Scalia's passing. Whether or not you're a close follower of the Supreme Court or consider yourself a devotee of constitutional jurisprudence, Justice Scalia is someone you should know about, appreciate, and honor, both as a jurist and as an exemplary American citizen. He was truly one of the great Americans of our time. The unfortunate fact of our present moment is that the Supreme Court is a highly politicized institution. Commentators and politicians often think of the court in terms of its supposed ideological composition. You have the liberal bloc on one side, the conservative bloc on the other, and a couple of justices who try to inhabit a middle ground. In this vein, we might be tempted to think of Justice Scalia as the hero of the conservative bloc. This would do him a disservice for a number of reasons, I think, but it significantly misses the basic fact that Justice Scalia's impact on the court and in our legal culture more broadly simply transcends partisan and ideological divides. As Justice Elena Kagan has observed, Justice Scalia will go down in history as one among only a handful of truly great Supreme Court justices. He changed the way that we talk about law and the way that we frame legal arguments. So a few of us in the political science department and the Torrey Honors Institute thought that we can't let this moment slip by us. We've got to bring some scholars together who can help us better understand Justice Scalia and his impact on our country governed by laws. Help us answer the question, how does Justice Scalia help us to understand the Constitution and our laws and what it means to be an American? We're delighted tonight to have three very distinguished scholars with us this evening, Professor John Eastman, Professor Ralph Rossum, and Professor Michael Uhlmann. If I did each of them full justice and introduction, it'd take up way too much time, so I'm going to give abbreviated introductions so that we can get on to the things that really matter. Dr. John Eastman is the Henry Salvatore Professor of Law and Community Service in the Chapman University Fowler School of Law. He also served as the dean there from 2007 to 2010. Prior to joining the law faculty at Chapman, he served as a law clerk with Justice Clarence Thomas at the Supreme Court and with Judge Michael Ludig at the U.S. Court of Appeals for the Fourth Circuit. After his clerkships, Dr. Eastman practiced with the national firm of Kirkland & Ellis, specializing in major civil and constitutional litigation. Dr. Eastman holds a JD from the University of Chicago School of Law, where he graduated with high honors, a PhD in government from the Claremont Graduate School, and a BA in politics and economics from the University of Dallas. In addition to a host of law review articles and other scholarly publications, Professor Eastman is co-editor of the American Constitutional Order, History, Cases, and Philosophy, now in its 4th edition. Dr. Eastman will be speaking to us tonight on Scalia's impact on the court and beyond. Dr. Ralph Rossum is a Salvatore Professor of Political Philosophy and American Constitutionalism at Claremont McKenna College. Over the years, he's held numerous leadership posts in the Academy, including serving as director for many years of the Liberty Fund's Judicial Seminar on the Constitution, a program for federal judges on the drafting and ratification of the U.S. Constitution and the Bill of Rights. Dr. Rossum is the author of many books, including Antonin Scalia's Jurisprudence, Text and Tradition, and Understanding Clarence Thomas, The Jurisprudence of Constitutional Restoration. Dr. Rossum holds a PhD from the University of Chicago and a BA from Concordia College. He will be speaking to us tonight on Scalia's jurisprudence. Finally, Dr. Michael Uhlmann is Professor of Government and Director of the Tribal Administration Program at Claremont Graduate University. He's had a diverse career, from private legal practice to philanthropy to public service, think tanks, and the academy. He's been senior vice president of the Bradley Foundation in Milwaukee, Wisconsin, and a senior fellow at the Ethics and Public Policy Center in Washington, D.C. As to his distinguished work in government, in 1974, he was confirmed by the Senate and appointed by President Gerald Ford to be Assistant Attorney General for Legislative Affairs in the Department of Justice. From 1981 to 84, he served as Special Assistant to President Ronald Reagan and Associate Director of the White House Office of Policy Development. He directed legal administrative policy for the Reagan presidential transition in 1980 and 81, and chaired the Department of Justice transition team for President-elect George H.W. Bush in 88 and 89. He holds a PhD in government from Claremont Graduate University, an LLB from the University of Virginia, and a BA from Yale University. Professor Uhlmann has written for many leading newspapers and journals of opinion, including National Review, the Los Angeles Times, the Washington Post, and the Claremont Review of Books. His talk this evening is entitled Scalia the Man, and he'll be speaking more personally about the kind of person Antonin Scalia was. After each of the panelists has given their individual presentations, Dr. Scott Waller of the Political Science Department will moderate some further discussion on themes raised in their talks, and then he'll open the floor to you for some questions and answers. Professors, we're delighted and honored to have you here with us this evening. Thank you so much for taking the time to be here. Without further ado, I'll turn it over to you, and please join me in welcoming our distinguished panel.
Well, I've been asked to lead off, which I'm happy to do.
That's Uhlmann.
I only do what I'm told, Tony, so, as you know. Well, it's a great pleasure to be at Biola. I haven't been here for a few years. As you know, Professor Guerra and Waller are products of CGU, the latter of whom survived my terror. When I first met him, he had a lot of hair. But as you know, he's wiser and a better man because of it. So he also has wonderful taste in wives, if I may say. He's a very lucky man.
Wives?
Who's counting? Well, I've been asked to say a few words about my late friend, whom I first met. It was 1971, I think. I had recently come to Washington to work for the Senate Judiciary Committee to defend what my then eldest daughter, aged 2.5, called the Electrical College. And Scalia, I will now refer to him as Nino, everybody called him Nino, had come to Washington to accept an appointment as a general counsel to a small little agency called it dealt with the regulation of cable television. Office of Telecommunications Policy is what it is. It's just a little three-man shop. He was there about a year, then went over to run the administrative conference, and another small government entity that dealt with the regulation of administrative law, one of his specialties. A mutual friend got us together, and we hit it off immediately by having a common sense of humor. He liked and disliked all the right people for all the right reasons, as did I, and we discovered that was a nice bond. The other element was we discovered that he had grown up about 6 blocks from my grandmother's house in Elmhurst, Queens, and we told old stories about that neighborhood, so we hit it off immediately as friends. We stayed in touch over the next couple of years by a concatenation of chance events, which neither of us could have predicted, which included, among other things, the whole Watergate mess. Nino ended up as Assistant Attorney General for the Office of Legal Counsel, and I, by a quite circuitous route, ended up as Assistant Attorney General for Legislative Affairs, which brought us together in late 74, early 75, and we would see each other virtually daily. for the next few years through the end of the Ford administration. It was an interesting department, to put it mildly. The Attorney General brought in by President Ford was Edward Levy, who had been, at the time, president of the University of Chicago, former dean of the law school, a very distinguished lawyer. Edward assembled an interesting cast of characters. Nino at the Office of Legal Counsel. Robert Bork was the Solicitor General. A fellow by the name of Rex Lee was the head of the Civil Division. Rex was the first dean of the BYU Law School, and after the department, his term in the department, would go on to become the president of BYU University. And yes, he is the father of Mike Lee, the senator from Utah. The Deputy Attorney General, the COO, if you like, of the department, was a fellow named Harold Tyler, who came off the bench of the Southern District of New York to help Levy run things administratively. And he brought with him a young lawyer from the U.S. Attorney's Office by the name of Giuliani. The head of the criminal division was the former U.S. Attorney in Western Pennsylvania, named Dick Thornburg, who would later go on to become governor of Pennsylvania, the best governor in the 20th century of the state of Pennsylvania, if I may say. You can look it up, as Casey Stengel would say. Very interesting cast of characters. Who did I leave out? I think, Peter Taft, who ran the Lands Division, now the Environmental Division. Peter's grandfather was someone by the name of William Howard Taft, whose name you may have heard of. His uncle was Robert Taft, U.S. Senator from Ohio, and his cousin was another Robert Taft, who also served as senator from Ohio. And Tom Kuiper, who ran the Antitrust Division, had more degrees and more clerkships than anybody could imagine, and taught antitrust at the University of Michigan Law School for many years. With my exception, it was the brainiest group of people you would want to assemble in one place at one time. And it was a great tribute to Edward Levy that he was able to pull this crew together. We bonded in a curious kind of way because this was post-Watergate, and the guns of Congress and the guns of the press were very much focused on the Justice Department. And one of the things, the major thing really, that Edward Levy did by force of his reputation and personality was to save the department from guerrilla raids on the part of Congress and the media, preserved its integrity, and thereby, we believe, the rule of law as such. A good deal of our activity, all of us really, was spent defending the prerogatives of the presidency. Then and there, you could say, if it wasn't already formed, Scalia's opinions about the separation of powers, and especially that Hamiltonian sense of the executive, which animates so many legal officers in the executive branch. It was then and there that it was formed, or if it had been previously formed, hardened, and served a very good function. By the grace of God, Gerald Ford was not elected president. Jimmy Carter was. And in a brief interregnum period, Bork, Scalia, and I found ourselves temporarily at the American Enterprise Institute before going on to real life. Great little enterprise, which is very enjoyable, gave us a little break between government service and other things. Nino went on to become a very distinguished professor at the University of Chicago Law School. He had previously taught at my alma mater, University of Virginia Law School, before he came to Washington. Then, again, by the grace of God, in 1980, Ronald Reagan was elected president. And by chance, I happened to luck into a few positions, both during the transition and later in the White House, very much concerned with legal policy. And I'm telling no secrets to say that among those of us who dealt with legal policy in the Reagan administration, there were two names at the top of our list of people we wanted to consider for serious judicial appointments. One was Robert Bork, and the other was Antonin Scalia. Both went into what Scott Waller would call the AAA ball. on the D.C. Circuit while we waited and hoping that God would smile yet again to produce vacancies on the Supreme Court. It was a close call originally. I was not in the final meeting in which Scalia was selected for the seat that opened in 1986. I suspect, I do not know for sure, I suspect it ultimately had to do with age. He was 10 years younger than Bob Bork, and that was perhaps the reason why he got the nod. And in any event, it was a terrific appointment. I think without question, Scalia was the most influential justice of the last half of the 20th century. You could even make a case that he may have been the most successful, most effective justice of the entire century. His skills were numerous. First and foremost, his brilliance. No one who ever encountered him could say otherwise. But there are many brilliant men who have served on that court. But he combined this with an extraordinary work ethic. He was an indefatigable worker. He got up earlier, went to bed later, worked weekends on all sorts of things. He set as his goal the desire to reform to the extent he could the mischief-making in American law. He was gifted with an extraordinary rhetorical power, which he used to great advantage in his opinions. He is the most quotable of all justices, I think, of the 20th century. The only people who might come close to that would be Robert Jackson, who served during the New Deal and Truman eras, and before him, Oliver Wendell Holmes, Jr. Beyond that, I don't think anyone is close to him as in terms of his rhetorical powers, which explains a lot of his influence in the body politic. When exactly he decided to write as extensively and vigorously as he did, I cannot say, but we would have lunch fairly often. Our favorite hangout was a joint that both of us had discovered quite separately as undergraduates, known as the AV Ristorante. Now, alas, gone. But it was a wonderful joint, a wonderful Sicilian joint that we both frequented and held high conspiratorial sessions in the back room that the owners had reserved for the justice. And we had many interesting conversations there. Nino used to take his clerks there 3 or 4 times a year, where they could order pizza with anchovies with pizza, or pizza with anchovies. They could have any of those 3. It was fine with them, but they had to have the anchovies and the pizza. It was a great joint. Many wonderful conversations were had there, which we did with some frequency. Among his other notable attributes, his personal kindness, which I can testify to, was extraordinary. His sense of humor was, like his work ethic, indefatigable. I still hear in my ear his laughter. It was natural, it was broad, it was spontaneous and gusty. No one, even his enemies who ever encountered him, could forget that laugh. He was, importantly, a Christian gentleman in the fullest and best sense of that term. To explain him, his ideas, his attitude, his work, without reference to his deep reverence for his creator is to miss a large part of the man. He was extraordinary in that respect. We went on a number of spiritual retreats together where we tried to mend our broken souls in diverse ways, and I can testify personally to how seriously he took his faith and how seriously it mattered to him and that wonderful family of his. He had 9 children, and the loveliest woman God ever made. He was once asked what the secret of his long marriage was, to which he said, Maureen said if we ever split up, I had to take the kids. And she probably meant it. He certainly believed it. He was ferocious in argument, but never personally. Well, almost never personally. Certainly not intentionally. He believed in truth, and he believed the way you got at truth was to argue for it and to make the best argument you could and to counter opposition arguments wherever you saw them. He fiercely promoted his ideas and had, I think, a huge impact in certain areas. Ralph and John will develop some of that, but I want to mention a couple of notes, characteristic notes of his jurisprudence that came up not only in his opinions, but in many conversations that we had. One note on his humor, one of my favorite tales is the most conspicuously important liberal justice on the court, going back to the Warren days, who still served after Nino came on the court in 1986, was William Brennan, who got on famously with Scalia on a personal level, but they agreed on nothing except the right time and a few other things of that sort.
And even that was only
and even that was
yeah.
arguable, yeah. But at a birthday party for Bill Brennan, maybe it was his 80th or 85th, his clerks had arrayed his most famous opinions out on a table, and in the presence of Brennan, Nino walked up and said, so little time and so much to overrule. That humor got him enormous fans, even among his enemies. I will give you another couple of samples of this because they're important. His favorite opinion was his dissent in Morrison versus Olson, the case in which, unfortunately, Chief Justice Rehnquist, who ought to have known better, upheld the constitutionality of the special prosecutor statute. Nino was only on the court 2 years when he wrote his dissent. It is a magnificent piece of work. It is rhetorically de gustibus, as they say. It's brilliant substantively. And if you want a short course in the separation of powers, you could do little better than to read that opinion. It is a magnificent piece of work, and it was his favorite piece, I think. And the opening line of the opinion is, frequently an issue of this sort will come before the court clad, so to speak, in sheep's clothing. But this wolf comes as a wolf. Right away, he's got you. He did this so often, so tellingly. I have encountered this with my students, and perhaps some of your professors haven't, perhaps you on your own. Once you get into the habit of reading a Scalia opinion, it's like getting heroin. It's hard to get rid of, and once it's in your system, boy, it sure feels
You did study at Yale, didn't
I
you?
did. Another one of my favorite lines, again from one of his dissents in the Mastretta case, which involved the constitutionality of the United States Sentencing Commission, one of these hobgoblinized, a little bit of Congress, a little bit of the judiciary, a little bit of the executive branch, and as Harry Blackman said in his majority opinion, oh, what the hell, they have to do something. Somebody's got to do it. Scalia dissented again vigorously, upholding the strictness of the separation of powers and bright lines between the three branches, which this commission violated. And he said, in summary fashion, he says, the commission is meant to act as a sort of junior varsity Congress, right? And in that sentence, he captures exactly the essence of this institution. It was going to make rules, and never mind that judges were making the rules as if they were Congress, and they would be equally binding on the other branches. He had this wonderful way of pithily coming at it. I will give you his favorite line of all. It came from an obscure DC Circuit case involving the regulation of meat products. His opening line there was, this case, involving legal requirements for the content and labeling of meat products, such as frankfurters, affords a rare opportunity to explore simultaneously both parts of Bismarck's aphorism that no man should see how laws or sausages are made. He did this kind of thing wonderfully. And in those, it's not just his eloquence, but the way in which those kinds of quotations capture the essence of the case. Right away, he's right on top of it. He had this wonderful ability to land on top of an issue in a very dramatic kind of way. He decided, I'm guessing, I'm not altogether sure, in between our lunches, I think it was 89. He's on the court 3 years at this point. Maybe he decided beforehand. I got the impression around 89, I think it was after the Webster case. He decided to write passionately and intently, and if need be, in dissent. And his audience was no longer his colleagues on the court, but students. And in that, he succeeded magnificently. There was no justice on that court in his or perhaps any other time who ever had such a large following among students, especially but not exclusively law students. And he succeeded very dramatically in that. And what he did, I think, not altogether successfully, but not for want of trying, and herein lies, I think, one of his great achievements. He altered the terms of debate. The answers are frequently less important than the questions that are being asked. And one of Scalia's enormous achievements is to change the terms of debate so that more or less everyone now argues, one side or the other, about originalism. That idea had been kicking around for a long time, but it was Scalia who put it on the map. It was Scalia who made originalism respectable in the courts of law and in the law schools, and for that we owe him a great debt. We owe him as well, I think, his powerful eloquence on the separation of powers and why it matters, not just for the branches of government, but for the protection of rights. Those of you who are familiar with Alexander Hamilton's argument in Federalist 84 about rights and bills of rights, terribly important, but at the end of the day, it is the structure of the Constitution that secures rights. Every constitution in the world has long lists of rights attached to them. They mean nothing because the structure of those constitutions is so weak. Scalia understood this implicitly and articulated it in a way that it had never been articulated, it seems to me, in the 20th century at least, by anyone on the Supreme Court. And in that, he brought that up on everybody's radar screen and made his colleagues, even the liberals, take it seriously. His general view was, articulated in many contexts, was that general rules of general applicability were good. They were good for the court. They were good for citizens. They gave instructions without too much detailed elaboration. And above all, they limited the discretionary authority of judges to take liberties with what the law said. He was death on levels of scrutiny. Some of you know these levels of scrutiny from common law: strict scrutiny, intermediate scrutiny, ordinary scrutiny, or what I call semi, demi, hemi, quasi-scrutiny. The court has invented all of these things. These are devices invented by the judiciary to decide how cases should come out, which so remove the testing from the actual law that the court is now interpreting its own doctrine and its own powers rather than the rule itself. Nobody articulated better than Scalia on the bench and in his off-the-bench writings the necessity and importance of rules of general applicability and why balancing tests and these levels of scrutiny tests were all a lot of palaver. He was death on that and significantly, I think, had a huge impact. Even his liberal colleagues, most importantly, Elena Kagan, with whom he got on personally very well, he introduced her to hunting, among other things. He was a great hunter, I ought to have mentioned that. He got that from his grandfather, who had been a great hunter in Italy, and introduced him to weaponry and hunting when he came to the U.S. Well, he introduced Elena Kagan, a city kid, to hunting, and she ended up loving it. She said in a very nice set of remarks she delivered upon his death, the finest compliment Nino would appreciate it, other than her remarks about what a kind and decent person he was. She said, "We are all textualists now." That was his motif. The words, what do the words say? What do the words mean? That's the craft of the lawyer. Not imaginary laws, not imaginary rules made up by justices. not preferences for what you might like. His impact there was enormous. Two other things I should mention in terms of substance, and perhaps Ralph and John will talk about it. His impact on the rules affecting standing. Who has the authority to bring lawsuits in federal courts? The court in the post-Warren Court era had become very lax on this. Scalia was the moving force, aided in particular junctures by Chief Justice Rehnquist, tightening the rules of standing, and that is a tremendous contribution to the body politic. And then finally, his bête noire was legislative history and the use of legislative history by courts. Legislative history is largely manufactured by members of Congress and their staffs. I plead guilty on this. In fact, in our first conversation, I won't take credit for it, but I think I put him on the qui-vive when it came to legislative history. The idea was already in his mind, but I told him some of the mischiefs that were taking place on the Hill, in which committee reports and endless pages of the Federal Register were filled with gaseous eruptions from people like me with too many degrees and too much time on their hands, explaining the statute. And the courts would fall into this, and they'd pick up all this rhetoric written by earnest staffers in committee reports and the congressional record, and use that as the interpretation of the statute. Scalia put a stake through that heart as best he could. It still rises from time to time, but he by and large killed it. Let me end by quoting to you from one of my favorite cases. This is a concurrence he wrote in a First Amendment case called Lamb's Chapel. And in here he alludes to the famous Lemon test, which perhaps some of you are familiar with, which puts such a quietus on, in Establishment Clause cases on religious activity. Here is Scalia at his best and brightest. As to the court's invocation of the Lemon test, like some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried, Lemon stalks our Establishment Clause jurisprudence once again, frightening the little children and school attorneys of the school district. Its most recent burial, only last term, was, to be sure, not fully 6 feet under. Our decision in Lee versus Weissman, that was a graduation school prayer case, conspicuously avoided using the supposed test, but also declined to repudiate it. Over the years, however, no fewer than 5 of the currently sitting justices have, in their opinions, driven pencils through the creature's heart. The author of today's opinion repeatedly, and a 6th joined in opinion doing so. The secret of the Lemon test's survival, I think, is that it is so easy to kill. It is there to scare us and our audience when we wish it to do so, but we can command it to return to the tomb at will. When we wish to strike down a practice it forbids, we invoke it. When we wish to uphold a practice it forbids, we ignore it entirely. Sometimes we take a middle course, calling its 3 prongs no more than helpful signposts. Such a docile and useful monster is worth keeping around, at least in a somnolent state. One never knows when one might need him. Now, in those 2 short paragraphs, you know everything you need to know about Establishment Clause jurisprudence, the Lemon test in particular, and Antonin Scalia, and why he is a great man, and why I miss him terribly. Thank you.
Well, I'm Ralph Rossum, and I was asked to speak about Scalia's jurisprudence. During his long and distinguished career, Scalia wrote 808 opinions, Supreme Court opinions. 273 of them were majority opinions. 20 were opinions announcing the judgment of the court. 84 were concurring opinions. 229 were opinions where he concurred only in the judgment, and often concurred in the judgment in part and dissented in part. And he wrote 202 dissenting opinions. Quite an output. Maybe a number of you are surprised to see that he wrote more majority opinions than dissents, given the coverage of Scalia at the time of his death. In 1987, 1 year after Scalia's confirmation as an Associate Justice on the court, a study revealed that only 7% of the briefs filed before the Supreme Court made originalist arguments. 20 years later, 35% of the briefs did, and this is no accident. Scalia arrived at the court where the justices were generally results-oriented, embracing some notion of a living Constitution, the belief that the Constitution is essentially an empty vessel into which they could pour whatever new wine they wished. They saw the Constitution as having no permanent and fixed meaning, but rather as a living, evolving document that must be interpreted to conform to the times. Scalia utterly rejected that view. He insisted instead that the times must conform to the Constitution, and he pulled the court in an originalist direction, initially single-handedly, and later in tandem with Justice Clarence Thomas. During his nearly 30 years on the court, Scalia assiduously and consistently pursued what could be called either a textualist jurisprudence or an original public meaning jurisprudence. He argued that primacy must be accorded to the text, structure, and history of the document being interpreted, and that the job of the judge is to apply the clear textual language of the Constitution or statute when possible, but if it's ambiguous, if it yields conflicting interpretations, Scalia then turned to the specific legal tradition flowing from that text to what that meant to the society that adopted it. Text and tradition is a phrase that filled Justice Scalia's opinions. Judges, he argued, are to be governed only by the text and tradition of the Constitution, not by their intellectual, moral, or personal predilections. That meant for him consulting dictionaries of the era and other founding era documents in order to ascertain what the words and phrases of the Constitution meant to the society that adopted it. For Scalia, reliance on text and tradition was a means of constraining judicial discretion. Scalia believed that the main danger of judicial interpretation of the Constitution, or for that matter of any law, is the judges will mistake their own predilections for the law. Faithful adherence to the text of the constitutional or statutory provision, or if that is ambiguous, to the traditional understanding of those who originally adopted it, reduces the danger that judges will substitute their beliefs for society. Perhaps the most illustrative example of Scalia's textualist or original public meaning approach to the Constitution is his majority opinion in District of Columbia against Heller, the 2008 case in which he held for a 5-member majority that the Second Amendment secures an individual right to keep and bear arms for purposes of self-defense. The Second Amendment reads, a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. In the decades leading up to District of Columbia against Heller, these words had been understood to secure only the collective right of militias to keep and bear arms. And since 18th century state militias no longer existed, having been replaced by modern police departments and National Guard units, the Second Amendment was considered to be a dead letter, repealed by the passage of time. Scalia rejected this conventional wisdom. He pointed out that the right was personal and pre-existing. The Second Amendment did not confer on the people the right to keep and bear arms. Rather, it secured it, just as the First Amendment does not confer on us the right to free speech and press, but simply secures it. Having done that, Scalia then, in classic textualist fashion, proceeded to parse the words of the Second Amendment, and he focused on 18th century legal dictionaries and encyclopedias to ascertain what such words as keep, bear, arms, well-regulated militia, free state, what those words meant to the members of the First Congress who adopted the Second Amendment and to the members of the state legislatures who ratified it. In Heller, his original public meaning approach led him to what many would consider a conservative conclusion. But in many other cases, especially cases concerning Bill of Rights criminal procedural guarantees, it led him to what many would consider to be liberal outcomes. His approach made him a fierce defender of the Fourth Amendment and its protections against unreasonable searches and seizures. One of my favorite cases in this regard is Kylo against the United States. In this case, he wrote the majority opinion overturning the conviction of a marijuana grower because federal agents did not secure a search warrant before using a thermal imaging device to detect heat radiating from his house generated by high-intensity lamps used to grow marijuana plants. This is the key provision in his opinion. In the case of the search of the interior of homes, the prototypical and hence most commonly litigated area of protected privacy, there is a ready criterion with roots deep in the common law of the minimal expectation of privacy that exists and that is acknowledged to be reasonable. To withdraw protection from this minimum expectation would be to permit police technology to erode the privacy guaranteed by the Fourth Amendment. We think that obtaining by sense-enhancing technology any information regarding the interior of the home that could not otherwise have been obtained without physical intrusion into a constitutionally protected area constitutes a search, at least whereas here the technology in question is not of general use. The area protected, the area constituted as at least where it was in this new technology was not in common use. This assures the preservation of that degree of privacy against government that existed when the Fourth Amendment was adopted. On the basis of this criterion, the information obtained by the thermal imager in this case was the product of a search. Now, in the United States against Virginia, the famous VMI single-sex admission case, Scalia made the argument that the purpose of the Supreme Court in interpreting the Constitution is to prevent backsliding from the degree of restriction the Constitution imposed upon democratic government. Scalia would have seen admission of the evidence based on the thermal imager to be backsliding from the amount of protection people enjoyed under the Second Amendment, the Fourth Amendment in 1791 when it was ratified. His textualist approach also made him a fervent advocate for the Sixth Amendment right to trial by jury, a right in one opinion he called the spinal column of American democracy. In Blakely against Washington in 2004, he argued for a 5-member majority that the right to trial by jury requires that every element of a crime for which a criminal defendant can be sentenced must be proved by a jury beyond a reasonable doubt or pled to by the defendant, and that the Sixth Amendment prohibited judges on their own from enhancing the sentence based on the findings of probation officers in their pre-sentence investigation reports. His textualist approach also made him the most stalwart protector of the Sixth Amendment right of criminal defendants to confront witnesses against them. He wrote the majority opinion in Crawford against Washington in 2004, in which he held that the Confrontation Clause flatly bars testimonial statements of witnesses who did not appear at trial unless they were unable to testify and the defendant had, in a prior occasion, had opportunity to cross-examine. He declared that, quote, where testimonial statements are at issue, the only indicium of reliability sufficient to satisfy constitutional demands is the one the Constitution actually prescribes, confrontation. In a 2011 case, Michigan against Bryant, he argued that a victim's dying words spoken to a police officer identifying his assailant should have been excluded because the defendant could not confront the witness. He wrote in dissent, Scalia declared the following: today's tale, a story of 5 officers conducting successful examinations of a dying man with the primary purpose of obtaining and preserving testimony regarding his killer, but of not doing that, but of rather protecting them and the man and others from a murderer who might somewhat still be on the loose, is, quote, so transparently false that professing to believe it demeans the institution. He found that, quote, reaching a patently incorrect conclusion on the facts is a relatively benign judicial mischief because it affects only the case at hand. But he argued the court's opinion here was anything but benign. Quote, in its vain attempt to make the incredible plausible, or perhaps as its intended second goal, today's opinion distorts the Confrontation Clause jurisprudence and leaves it in a shambles. Instead of clarifying the law, the court makes itself the obfuscator of last resort, because I continue to adhere to the Confrontation Clause that the people adopted, as described in Crawford. I dissent. Now, Scalia applies the same text and tradition approach across the constitutional landscape. In a First Amendment jurisprudence, in the religion clause cases, he demonstrated it with quite an effective way. In the Ten Commandments case of McCreary County against ACLU of Kentucky, his textualist approach led him to respond to Justice David Souter's assertion that the Establishment Clause mandates government neutrality between religion and non-religion. And his reaction to that was, who says so? Surely not the words of the Constitution. Surely not the history and traditions that reflect our society's constant understanding of these words. Surely not even the current sense of our society, recently reflected by an act of Congress adopted unanimously by the Senate and with only 5 nays in the House, criticizing the Ninth Circuit's opinion that the words in the Pledge of Allegiance under God were unconstitutional. And concerning the free exercise clause, it led him to conclude in the controversial majority opinion in Employment Division, Department of Human Resources of Oregon against Smith, that, quote, as a textual matter, there is no need to provide a religious exemption to a generally applicable statute, and that to make an individual's obligation to obey such a law contingent upon the law's coincidence with his own religious beliefs, permitting him by virtue of his beliefs to become a law unto himself, contradicts both the Constitution and common sense. His textualist approach led him to a number of conclusions that again would seem contrary to his own political predispositions. In a series of cases dealing with the Due Process Clause, he found that the government could, completely consistent with the traditional understanding of due process, pass laws that allowed for unlimited punitive damages, grant visitation rights to grandparents against parents' wishes, prevent suicide, criminalize homosexual sodomy, and pass it whatever laws it wanted concerning abortion. And finally, Michael emphasized Scalia's emphasis on separation of powers. His approach led him to preserve separation of powers, ruling both for and against legislative, executive, and judicial branches when the text and traditional understanding of the Constitution required it. In Morrison against Olson, in Prince against United States, Lujan against Defenders of Wildlife, he defended executive power and judicial power from congressional encroachment. In the recent case of NLRB against Noel Canning and Zivotofsky against Kerry, he defended congressional power from executive overreach. In Hein against Freedom from Religion Foundation, he sought to rein in judicial power. And near the end of his life, he started to see the importance in some areas of reasserting judicial power. In a case called Talk America against Bell Telephone Company and Perez against Mortgage Bankers Association, he sought to reassert the power of the Supreme Court and in general from the way it had relinquished considerable power to the administrative state in cases like Chevron USA against National Resources Defense Council and Auer against Robbins. Scalia's untimely death prompted several symposia. This is the most recent. One of them was a symposium of law professors and others in Politico magazine. Two of the reflections, one by a conservative, the other by a liberal, capture well his legacy. Michael McConnell, the Mallory Professor of Law at Stanford and director of its Constitutional Law Center, wrote the following: Antonin Scalia was the most significant and influential Supreme Court justice of the last 30 years. By sheer force of intellect and personality, Scalia helped move the court from a somewhat sloppy, results-oriented center-left institution to a more intellectually rigorous center-right court that forefronts text and history over other modes of interpretation. In the course of this, he, along with a handful of other judges and academics, gave birth to the modern conservative legal movement. He was beloved by his friends and not infrequently by his adversaries. McConnell went on to remark that on such matters as separation of powers, freedom of speech, and how to read the Constitution, quote, this was not just a vote among 9 on the court, this was a mighty pen guided by a sharp analytical mind that cared deeply about the nation's fundamental charter. Michael McConnell on the right, William Eskridge at Yale Law School on the left. He also focused on Scalia's textualism. Scalia was the Supreme Court's rule of law conscience, often in noisy dissent and grumpy concurrences. I love that phrase, grumpy concurrences. But increasingly, as the author of majority opinions, Scalia reminded, admonished, and scolded his colleagues in the entire legal community that modern law is all about public text, the text of statutes, of agency regulations, and the text of the Constitution itself, and that the job of the judge is to interpret the text according to the ordinary meaning read in the context of the whole act and with regard to precedent and tradition as well. With slight exaggeration, his motto might have been the text, the whole text, and nothing but the text, so help me God. Eskridge made the point that by focusing on the text, it makes it difficult for judges to reach convenient conclusions. Let me find a place to begin here. His was and remains an important voice because judges facing hard cases are constantly tempted to read their own preferred results into legal texts whose ordinary meaning and the overall course of law often runs in the opposite direction. Eskridge's words recall a comment that Scalia made on January 28, 2013 at Southern Methodist University Law School, where he and Brian Garner, his co-author on a big fat book called Making Law, were revealing the book. Scalia made the statement, "The judge who always likes the results he reaches is a bad judge." 6 weeks after his death, George Mason's law school announced that it had received $30 million in combined gifts, $20 from an anonymous source and $10 million from the Charles Koch Foundation
Thanks, John.
to support the law school and to rename it the Antonin Scalia Law School. Upon learning this news, Ruth Bader Ginsberg, Scalia's dear friend and colleague on the court for over 20 years, issued a statement. Justice Scalia was a law teacher, public servant, legal commentator, and jurist non periel. Expressing her delight that the law school would bear his name, she declared, "May the funds for scholarship, faculty growth, and curricular development aid the Antonin Scalia Law School to achieve the excellence characteristic of Justice Scalia, Grand Master in life and law." Her heartfelt words are a fitting conclusion. Thank you.
So Professor Uhlmann told you everything about Scalia the man, and Ralph told you everything about Scalia the jurist. There's not much left to say. I feel a little bit like Liz Taylor's third husband. I know what my duties are, but I'm a little uncertain about how to make it interesting. Let me see what I can do. To really understand the impact of Scalia on jurisprudence, I think you have to put yourselves back in what things were like before Scalia. There are editions of constitutional law textbooks that were published in the 1970s that don't even have a copy of the Constitution in it. Now, think about what that means. The Constitution by then had become irrelevant, largely as a result of one of Scalia's predecessors on the court saying, yes, of course the Constitution is the supreme law of the land, but the Constitution is whatever we, the judges, say it is, which means the latest judicial opinion is the supreme law of the land under that view, not what the Constitution says. And the text had become irrelevant, so irrelevant that many thought, why waste the pages in the book? Scalia almost single-handedly turned that understanding of constitutional law around, almost single-handedly because he had a little help. Ronald Reagan kind of launched this mission by appointing him in the first place, and Attorney General Edwin Meese, in a very famous speech launching the Originalism enterprise, kind of began the process in thinking about these things. But Scalia was the, applied scientist of this Originalism project. He's a guy that day in and day out for 30 years manifested this view that the Constitution is what it says it is, and that we have judges don't have any authority to remake it in our own image because we think that would make things more just or more fair or what have you. That there's actually a process in the Constitution for doing that. And so that was transformative. Now, how did it play out on the bench? Well, you take that view of the law and Scalia's own predisposition to being a sparring partner, and you can see a lively bench that just hadn't existed before and doesn't exist now. The 30 days after Scalia's death, his chair was draped in black, as is the court's tradition. But the loss of Scalia has affected that court well beyond that 30 days. In fact, Justice Alito was out at our Claremont Institute Churchill dinner just 2 weeks ago, a week and a half ago now, and said, you didn't dare, as a lawyer advocating before the court, start talking about legislative history without Scalia coming after you on the bench. And he said, I've noticed just in the years since Scalia's passing, these lawyers now are starting to do that again. And we all look to the other end of the bench to see what we all expect Scalia to do, and he's not there to do it. And so far, none of the other justices have taken up the mantle. He liked to spar. He liked to make sure to press the point, and he liked people to come back at him and press a point. If he was wrong on something, he wanted you to tell him, and he wanted to confront it and fix it. Now, he was also stubborn, and there were a couple times I thought he was wrong that he didn't fix it. We'll talk about those in a minute. But I want to do this by a couple of stories, this sparring partner story. So we'd invited Justice Scalia out to speak at Chapman Law School, where I teach. And the invitation got lost in the anthrax scare at the court. It was among the mail that was destroyed. And it was uncharacteristic of him. I never got a response to our invitation. And so the next time I was at the court visiting my old boss, Justice Thomas, I bumped into him in the hall. I said, "You didn't even give us the courtesy of a response." He said, "I never got it. Must have got caught up in the anthrax thing." He said, "But I do want to come out there. I just can't do a graduation speech." So you know what the term's like at the end of the term. He almost killed himself every year working so hard. He was more tired at the end of the term than any other justice up there. And he wrote his own opinions. He fine-tuned them to the nth degree. He would keep working on them until the moment they were going to come out. He said, "So I can't come that last month of the term. You know what it's like up here." I said, "But I do want to come out there. What do you want me to speak about?" I said, "Justice Scalia, you can speak about whatever you want to speak about." And he looked at me and he said, "Eastman, you're wrong about Lochner versus New York, so I'm going to come talk about Lochner versus New York." Now, I said, "Justice Scalia, next year is the 100th anniversary of Lochner versus New York, so we're going to reenact it, and you can play the Chief Justice, because that's as close as you're going to get to doing that." Now, it was fun. We were having fun, okay? And he came out, and we had this fabulous exchange. Justice Scalia took the bench as the Chief Justice of the Supreme Court. 9 students, 4 of them law students, 3 undergraduate students, joined the bench with him and participated in this reenactment of Lochner versus New York. Now, Lochner versus New York is a case about a baker and a guy that owned a bakery, and New York had imposed a law limiting the hours that people could work in bakeries to no more than 40 a week. Now, you could work 80 hours if you went and got a second job at a different baker, but you couldn't work 60 hours or 42 hours at the same baker. And this was arguably designed to kind of squelch competition from the upstart immigrant bakeries against the big corporate bakeries. And the court held that it was a violation of liberty to infringe on a man's right to earn his own living and negotiate his own contracts. Now, the liberty protection in the Constitution is actually a procedural protection. It's in the Due Process Clause. No state can deprive any person of life, liberty, or property without due process of law. And that means you can deprive them of life, liberty, and property with due process of law. Process. And this went through all the right processes. This legislation restricting bakers passed the legislature according to the terms of the New York Constitution. The charges against Mr. Lochner for violating the law were filed in court, and he was prosecuted and duly convicted. All of the procedural protections that the Due Process Clause was designed to provide were there. And yet the court nevertheless held that it violated liberty, that there was a substantive component to this due process. Now, historically, this was not what the clause was ever designed to do. And Scalia was right about that. But there was a provision right before that clause in the 14th Amendment that said all citizens are guaranteed the privileges and immunities of citizenship. And one of the privileges of citizenship was the right to earn a living without undue restrictions from the government. But we'd long written that clause out of the Constitution, and so we don't revisit it. So at this reenactment, I focus on the Privileges and Immunities Clause briefly, and Scalia says, "Oh, that's long dead. We're not going to revive that. What else you got?" Because he wanted this exchange. I said, "Well, it violates liberty in the Due Process Clause." He said, "What part of process includes a substantive right? What part of that phrase has any substance to it?" I said, "Well, I think it's in the word law, Your Honor." He said, "Law? Who said that?" I said, "Well, Your Honor, one day your court in the future is not going to like looking at foreign sources of authority, but this was Cicero. I think that's a pretty good one. Law is a substantive component." He said, "What state was Cicero from?" I wasn't ready to give up. I said, "Sicily, I think, Your Honor." But we had that exchange. By the way, the then Attorney General of California was arguing the other side of the case from me, Bill Lockyer. He didn't have any idea what was going on in this exchange. But Scalia and I had and he loved that. He loves it in his opinions as well. He loved it on just minor things like taking clerks out to AVs. I was the recipient of one of those lunches.
You had the anchovies.
No, I'm gonna give you the story. But you were right. He gave us 3 options. You can get pizza with anchovies, or anchovies with pizza, or pizza with anchovies. And I said, Justice Scalia, I don't like anchovies. I'm not going to eat anchovies. He said, real men aren't afraid to eat anchovies, Eastman. And I said, Justice Scalia, real men aren't afraid to say no to a justice. And so he loved that. I mean, this was, so anybody that would give back at him like that, became fast friends. There are a couple of points in his jurisprudence, though, that I want to focus on. Ralph talked about his textualism, and also the very important case, District of Columbia versus Heller, where Scalia applied that textualism. Of course, the Second Amendment, as originally drafted, applies as a limitation on the federal government, not on the states. And so when the next case comes up, it's out of City of Chicago versus McDonald. The question is, does the right protected against the federal government by the Second Amendment also apply to the states? And here is the Lochner versus New York question over again. How do we apply the rights of the Bill of Rights to the states? We do it via the 14th Amendment. Originally, the drafters of the 14th Amendment thought, and this is pretty well documented originalism, vintage Scalia, that these kind of things were going to be governed by the Privileges and Immunities Clause. Early on, the court in a case called Slaughterhouse basically eviscerated the Privileges and Immunities Clause. And so now we're confronted in City of McDonald. Do we apply the Second Amendment right to the states via the Privileges and Immunities Clause as the original drafters and ratifiers of the 14th Amendment clearly intended? I mean, there's a debate about this, which of the rights might apply, how broadly it applies. There's some ambiguity, but there were a couple of things they were certain about. And one of them was the right of the former slaves to own guns in order to protect themselves against the rising mobs of violence against them. This is patently clear in the legislative history of the 14th Amendment, but also in the ratifying debates. And so here's the question presented to Justice Scalia. Will you overturn that old Slaughterhouse case and go back to the pure originalist understanding of that language? Or will you adopt substantive due process as the means for incorporating the Second Amendment, which was exactly what the Lochner Court did, that you've been the leading critic of for most of your career? Only one judge on the court took the privilege immunities route. It was Justice Thomas. Justice Scalia joined with a majority decision that said the substantive due process clause, that process has substance to it, is the way we apply the Second Amendment to the states. It was a rather interesting dynamic for Scalia, the leading, I think one of the leading critics over the decades, over the century of Lochner versus New York. There were a couple of other things. Professor Uhlmann talked about some of his famous Establishment Clause decisions. One of my favorite lines of all of his, one of my favorite quips of all his of opinions comes in that Lee versus Weissman case. This was an 8th grade graduation, and the court held, Justice Kennedy writing the majority opinion, that it was unconstitutional to have a prayer at a graduation ceremony because some kids sitting in the schools might feel like they were compelled to participate in it. And so Scalia writes this line and says, the majority just simply misunderstands religion and the nature of religion. It's not something like pornography to be indulged only in the privacy of one's home. And only Scalia could get away with a line like that. It is rather something that most believers think has to have a public manifestation to it, right? And this was dramatically important for countering this move in our Establishment Clause jurisprudence that religion is something that exists only in the privacy of one's home or in the confines of one's sanctuary or synagogue. That for believers, religion is something that is 24/7. that you live your life according to your religious principles. That means in the public square, that means in who you vote for in office, in the political speech you engage in, it means how you conduct your business, whether it's Hobby Lobby or the Storman's Pharmacy in Washington or Melissa's Flowers and Bakeries. I mean, it applies in everything you do, and Scalia reminded us of that with that one little quip. I'm more critical on his free exercise jurisprudence, though, because here his textualism was too confining to be true originalism, in my view. And what do I mean by that? Well, starting with the text of the Constitution is a phenomenal good start, because like I said before, we had lost that by the time Scalia comes to the court. But the words alone don't fully capture what the founders had in mind by them. And I'll give you just a couple of examples. If you don't look to the political theory underlying the words, you're going to be just bollocksed behind belief on a couple of the words there. What does it mean to guarantee a Republican form of government? What does it mean to have a privileges and immunities? What is due process of law? All of these things require that you have some philosophical foundation that informs those words. Now, Scalia almost always gets to the right place by looking at the history and traditions of those words, because the history and traditions that gave us those words is full of the kind of philosophical foundation for them. But a couple of times, I think he gets it wrong. And it's very important to understand that and to see the most interesting fight on the court on Scalia's time there was not between Scalia and the conservatives on the one side and the liberals on the other. But it was this fight over this aspect of originalism between Scalia on the one hand and Clarence Thomas on the other. And it manifests itself most profoundly in a couple of cases. One is this fight over grandparents' visitation rights. The state of Washington had passed a law saying that any person can petition the court for visitation rights and against the will of the parents, not unfit parents, but perfectly fit parents, if the court determines that it would be in the best interest of the child. Justice Thomas and a majority of the court had no problem in finding that this protection of parental rights was fundamental and could only be restricted in the most urgent of circumstances. Justice Scalia said there's no such thing as parental rights in the Constitution. Maybe it's one of the unalienable rights protected in the Declaration of Independence, he says, but I as a judge don't get to decide what those are and certainly not enforce them from the bench. And so this was the fight between the two right there. It goes on about the relevance of the Declaration of Independence and constitutional interpretation more broadly. Scalia lays a broadside against the use of the Declaration in constitutional interpretation in that opinion. Justice Thomas's response in another case, on an equality affirmative action case, dealing with the federal government, which really doesn't have an equal protection clause that applies to it. Justice Thomas says this violates the principle of equality inherent in our Constitution. And his citation in just a very short citation response to Scalia's full diatribe here was cite Declaration of Independence, paragraph 2, right? And so there the fight was joined. But it also shows up in the notion of rights. Justice Scalia, as Professor Rossum pointed out, was very keen on forcing us into general rules of general applicability. And carrying that through to its conclusion in the free exercise of religion context, he writes this opinion in Employment Division versus Smith. The case involves a gentleman who worked for the state unemployment office, and he was fired because he smoked peyote. And part of his job in the unemployment office was not to give unemployment benefits to people who were on drugs. And so, there was some correlation here. But he smoked peyote because he was a member of a religious sect, that was part of their religious service. The prohibition, and so he made a free exercise claim that you can't hold me to the same standard that the generally applicable prohibition on this drug use does, because I have a free exercise right to do it, as long as it's not subject to strict scrutiny, to use the legal test. Does the government really have a compelling interest in not letting me use peyote for my religious ceremony? All right, and Scalia said, we're not going to get compelling interest. The religious practice here doesn't get any different protection than anything else. It's a generally applicable law, not targeted to religion, he says, and therefore, It's only subject to the normal rational review that we give all laws. Now, and he says at the end of his opinion, now you may find that the only people that then get adequate protection for their religious exercises are those of the more mainstream majority religions. We can't imagine, for example, a law, even a prohibition law, that prohibits the Catholics from, or not having an exemption for Catholic wine at Mass. And he said, if this seems harsh for minority religions, well, that's just tough. That's the consequence of living in a democracy. Now, what does Congress do immediately afterwards? It passes a heightened scrutiny statute called the Religious Freedom Restoration Act that tries to restore the strict scrutiny test for religious exercise claims. But what's particularly telling to me in this circumstance is that the text doesn't say anything about this, unless you look at it through the lens of the Declaration of Independence, which talks about inalienable rights that pre-exist government. And this ruling that Justice Scalia gives us there kind of turns that notion of pre-existing God-given inalienable rights on its head. We now, by virtue of this decision, only have the right to our free exercise of religion, absent compelling reasons to the contrary, because government has given it to us by this statute, this Religious Freedom Restoration Act. The Hobby Lobby case and these other ones dealing with the contraceptive mandates in Obamacare all come up not on the free exercise clause of the Constitution, but under this statutory test, which can just be as easily taken away as it was given. In fact, the day after the Hobby Lobby decision came down, there was a bill introduced in Congress to repeal the Religious Freedom Restoration Act. And now that seems to have turned upside down the notion of inalienable rights that pre-exist government, that we only have the right to exercise our religion because the government has given it to us. It's not much of a right at all. Now, he won't, because he was stubborn, wouldn't admit that on the free exercise case, ever. But he did, when he gets to the Second Amendment case, apply that moral reasoning to the decision in Heller that the right pre-existed government. All of the arguments that I could make on the free exercise clause and what was wrong with his decision there, he actually makes in the Heller decision, and I think he was right there. Now, there's one other area where, despite his stubbornness, he made some acknowledgement of a prior error. This separation of powers, he was always one of the leading spokesmen for strict separation of powers, but there was this body of doctrines that had developed over time, like barnacles on an old pirate ship, that Scalia had actually contributed to. And I can understand why he contributed to it. And we got to, again, put ourselves back into the mindset of the late 1960s, early 1970s. The Warren Court was just rampant in making up things left and right that were constitutional rights, so they say, and they would use that to strike down perfectly valid exercises of the legislative power or perfectly valid acts of the executive. And Scalia and the administrative lawyers of the Nixon and Ford administration developed some of these doctrines to push back against the lawlessness or the freewheeling living constitutionalism of the Warren Court, saying we're not going to let the courts fill in the blanks on ambiguous statutes. We're going to defer to the executive agencies because at least theoretically those executive agencies are accountable to an elected official, the head of the executive branch, the president, and because of that control, there's accountability to the sovereign authority in the country, the people. Well, it turned out that that's not remotely true. And increasingly, these deference doctrines, whether it's Chevron deference or there's even one where we'll defer to the agency's guidance interpreting its own rule as it's enforcing it, called Auer doctrine, A-U-E-R. These doctrines ended up being freewheeling permission, blank checks for the unelected bureaucracy to basically make thousands and thousands of laws completely unaccountable to anybody. And Justice Thomas, about 4 or 5 years ago, starts pushing back against some of these doctrines and recounted to me a conversation he had with Scalia in the hallway at the court one time. He said, you know, Nino, we got to revisit some of those deference doctrines. And Scalia said, yeah, boy, they are just crazy, aren't they? They've gotten into a whole lot of trouble. Who could have done those in the first place? He said, well, Nino, you wrote one of them. He said, I know. That was within a few months of his death. And the fact that Scalia, on such a set of doctrines that he had been so part of making and fashioning, had realized his error, and that it was an error that ran directly contrary to his longstanding devotion to separation of powers, and his willingness to revisit that. And he said so. He said so publicly. He intimated in a couple of opinions. He didn't get to close that loop before he died. But his protege, Neil Gorsuch, who's the nominee to fill his seat, was already writing in those terms several years before Scalia acknowledged that the doctrines were wrong and needed to be changed. So in many ways, Gorsuch is the perfect person to kind of fill the seat of Justice Scalia and carry out that last mission that Justice Scalia had recognized needed to be done. Thanks so much.
Well, I just want to kind of continue the conversation a bit here and then turn the floor over to you, as obviously there's some things that may have struck you of interest, and this is a unique opportunity to talk to some folks that hopefully have impressed you as not just your ordinary run-of-the-mill folks that come and talk about these things at Biola University. So gentlemen, thank you, and Professor Eastman's last comment nicely bridges to what I'd like to do. I'd like to talk to you maybe and ask you a few questions regarding the future of the court. We've just heard a fascinating account of a man, his life, his legal legacy, who can aptly be described by both his advocates and critics as a legal giant. It leaves quite a vacuum on the court. And this man in 1986, I believe, was confirmed 99-0 in the United States, 98. With 2 abstentions in the United States Senate. If Justice Scalia was up for nomination today, this probably wouldn't happen. Rather controversially, President Obama's nominee, Merrick Garland, wasn't considered by the Republican-controlled Senate, and now President Trump's nominee, Neil Gorsuch, is up now. So here's my question. What do you believe the appropriate level of review for the Senate in instantiating its advice and consent role in the Constitution regarding presidential nominations should be? Should they simply look at a jurist like Neil Gorsuch and say, well, this man seems to be well qualified, possessive of judicial temperament, or should there be other kinds of standards that a senator should adhere to?
In a perfect world, it's like the old economist assumption, right? Assuming no transaction costs. In a perfect world, the president would have the primary role here, whether it's President Trump or President Obama or President Clinton or Bush or whatever. The president would have the primary role in nominating, and the Senate a more limited role that would prevent abuse of the president's authority by, to use the language that the founders used in the Federalist Papers and whatever, by picking people that were family members or clearly unqualified. And so you would limit the qualifications, do this have the qualifications in judicial temperament? But we haven't lived in a perfect world in the court since the 1960s, it seems to me. The court has taken upon itself a role that the Constitution does not envision. And having somebody that's well credentialed but understands a role that's contrary to its constitutionally assigned place seems to me that the Senate has a greater obligation to provide a check on that, because it's the only check we get on the judiciary. If you've got somebody that manifests an intent not to merely apply the law, but to refashion it, to make it better in their view, then that ought to be a disqualifying qualification no matter how well credentialed they are. And I'll give you one example of this that doesn't involve the Supreme Court, but the lower court. We've got a judge sitting on the Ninth Circuit Court of Appeals, even now, who was nominated by President Carter back in the late 1970s. And he was asked at his confirmation hearing, if the law of the Constitution was clear and it was contrary to your own personal views, which way would you rule in a case from the bench? To uphold the Constitution or to advance your personal views? And you can look the transcript up. The judge said, for my personal views. And the senator asked the question again. Maybe my question wasn't clear. Right? And he repeated what he had said. And he spent the last 40 years now on the bench proving that he meant what he said. That should have been a disqualifying statement because he was announcing on the front end that he was not going to honor the oath of office for a judge. And what should have happened then is that the Senate, honoring their oaths of office, should have rejected that nomination. They didn't. He was overwhelmingly confirmed. And it seems to me that that question, will you treat the role of judge as merely exercising judgment, not will or power, and do that in all cases. Do it like Justice Scalia said, if you're a judge that you like every outcome of every case you decide, you're not doing the job well. It seems to me that that has to be foremost in the senator's mind. And if we get judges that are not willing to subscribe to that role of the judiciary, they ought not to be on the court.
Okay. Well, let me ask a question, one more, and then turn it over to you all. So be thinking of a question that you might like to ask, and a microphone will be making its way around to you. Let me ask a question that hits pretty close to home here at Biola University. We're particularly interested in the aftermath of Senate Bill 1146. And perhaps the folks here don't know that the new California Attorney General has rather controversially during his confirmation hearing before the California Senate offered a view of the First Amendment that First Amendment religious freedom protections only apply at the level of the individual and not to the collective, which would certainly implicate us here at an institution of this sort. So my general question is, where do you see the direction of the law going in what seems to be a collision course at the court between the inevitable collision between religious freedom and the freedoms and liberties associated with the kind of newfound sexual liberties a la Obergefell and that kind of thing? So anybody could answer that.
So there is Professor Eastman was talking about the Religious Freedom Restoration Act, about the Smith decision, laws of general applicability. What's interesting, and what Scalia could have argued but didn't, is the framers of the drafters of the 18th Amendment, prohibition, didn't intend to leave it up to courts to determine whether communion wine should still be made available or not. If you read the careful text of the 18th Amendment, it says that alcohol is, for beverage purposes, is prohibited. Nothing about sacramental purposes. So it would be nice if legislatures would have the same regard for wanting to protect, not through courts, but through the way they draft, in that case, the 18th Amendment, or in the case of California, the measures you're talking about. It would be nice if legislatures could act with the same kind of diligence, commitment to the Constitution, commitment to religious freedom, that they also take an oath to uphold.
But I think that, go ahead, Mike.
No, go, Jeff.
But I think this goes to the heart of my criticism of the Employment Division versus Smith line. All of our public accommodation statutes are laws of general applicability. And so if the legislature chooses not to provide a religious exemption, you've got no ground to stand on. Your ability to exercise your religion in public, in a public accommodation, which would include any institution, because we've so distorted the notion of public accommodation. It means anytime you walk outside your front door, you're engaging in public activity, and if you provide any service, you're doing a public accommodation. That's a law of general applicability, and you've got no right under the modern view of these things to exercise your religion. That seems to have created an irreconcilable conflict with religious liberty. And it seems to me that we have to push back both against the doctrine that took root in Employment Division versus Smith, but also the notion that public accommodations were a very narrow subject. The old distinction was between government. The 14th Amendment prohibits discrimination by government. It doesn't prohibit, if I want to marry a woman instead of a man, that's discrimination on the basis of gender. It doesn't prohibit that because I'm not the government, right? The government is covered. A couple of exceptions to that early on. They date all the way back to medieval England. If you got the king's charter to build an inn out in the middle of nowhere, or to use their wonderful language, in the highways and byways of the realm, you had to take all comers. You couldn't discriminate. You were a public accommodation because of your license from the king. But it didn't apply to the hotels in town where if somebody wanted to say, I don't want you staying at my inn, you went down to the next door inn. Right? We've now expanded public accommodation, so it's every public business, it's everything. And that's what leads to the confrontation between the photographer who says, I don't want to exercise my talent to celebrate your same-sex wedding doing something that violates my religious beliefs. Or the pharmacist who's ordered to provide abortifacients contrary to his religious beliefs as a condition of continuing to stay in business and earn his livelihood. And so this massive expansion of public accommodation laws tied with the notion of general applicability rules don't get any religious protection have created a huge problem. And it's got to be fought back at the margins with things like the First Amendment Defense Act and those kind of things. But it seems to me that the problem is deeper than that. That aims at a symptom. It doesn't go to the underlying problem. And we've got to articulate the problem in very clear terms.
Let me say a good word on behalf of the Smith case. And it's a close case. It's good to teach, as you know. It's a very close case to call. From Scalia's point of view, can religious rights become a trump card for otherwise valid non-discriminatory laws? From a public policy point of view, can you allow somebody who says, I'm not going to obey that law because I have a religious belief? You can see the difficulty in this socially. And the First Amendment really says nothing about that on the face of it. So you have to think about it in a way that brings in the doctrine, as John was hinting at, it's sort of a metaphysical doctrine about reasonableness. Only reasonable religious objections can be recognized by the law. And that opens up a whole can of worms, I understand. The broader difficulty, especially for believers in our time, it seems to me, consists in this, and one has to pay serious attention to it. You have a conflict between two large social forces. One is the expansion of the understanding of what constitutes religion. Once upon a time, there was a series of more or less established religions, largely Judeo-Christian, throw in Islam and Hinduism, if you like, and a few others of that character. That was the understanding of religion. In the United States, it was largely Judeo-Christian, largely. What you now have in this increasingly secular age is a broadening of the definition of what constitutes religion. In the law, this was occasioned by a series of cases involving the Free Exercise Clause concerning the draft deferment. These were Court of Appeals cases, but they filtered over to the Supreme Court largely, in which people, if you want to say mockingly, said, I don't believe in God, but I believe in a great out there. Somewhere between the Bible and today, the great out there became, for purposes of law, a cognizable religion. When that happens, you now have this huge set of self-proclaimed rights, called now religion, and now ostensibly protected by the Free Exercise Clause. That's one side of the problem. The other side of the problem is this explosion of governmental activity, in which the government regulates everything in sight in a way it seldom did, certainly at the time of the First Amendment, and even in the course of my lifetime. This is a recipe for a social conflict of a very dramatic sort, and we're now beginning to see it happen, whether it's bakers or candlestick makers or whoever else confronting gay rights activists. And there's a lot more behind that, even beyond the sexual front. Big government and an enormously expanded understanding of religion, which goes far beyond what most people in this room would recognize as religion. That's going to conflict like this. What the law is going to do with this, I do not know, and neither does anybody else. This is a real problem. You got to keep your eye on it. Ultimately, I think this will be resolved politically rather than judicially. If people care enough to place weight on their congressman to say, we really care enough about this, then Congress will react in a way that I think the judiciary will take judicial notice of in their interpretations, but perhaps I'm wrong. I don't know, and I don't think anybody else knows. But this is a new conflict in the world of religious rights. So every claim that you make as a traditionalist in religion, the risk is it's going to be made by somebody who believes in the great spaghetti monster out there and thinks those rights should have equal status with those based on Judeo-Christian principles. How to limit that claim in our time, this very secular age, is a very difficult thing to do legally, and one needs to think about that.
And let me just add one thing. At the same time, the notion of religion is expanding. The things protected by religion traditionally understood are contracting. And you see this in just the manipulation of the language. We no longer talk about, in official documents, the free exercise of religion. We talk about the freedom to worship, right? And that does exactly what Scalia predicted it was going to do in Lee versus Weissman. It confines it to the synagogue or the church or the sanctuary, maybe your own home, maybe not. But don't think you get to exercise it out in public.
Yeah, don't sell cakes or flowers.
Yeah.
Exactly. Okay.
Okay, well, gentlemen, if you could indulge us a few questions from the audience. Jason has a mic. You can just raise your hand. And may I encourage you to make sure that what you ask is a question and not sometimes a statement. So we'll take over here and move from there.
How long do you think Congress, if at all, should wait before using the nuclear option to fill the Supreme Court vacancy?
Do you want me to do it? So, the filibuster rule is Senate made, and it was designed to encourage deliberation until we had a full vetting of a candidate. Over the years, it morphed into a supermajority requirement, which is not constitutional. In fact, I testified years ago before a Senate Judiciary Committee that I thought it was unconstitutional to actually alter the number requirement. So if the Democrats engage in that kind of filibuster, intending to block this forevermore until you get to 60 votes, then I think the Senate Majority Leader should do what the Democrats did for all the lower court judges, which is change the rule and do it by simple majority vote, as they're entitled to do, and then have the nomination voted up or down with a majority vote. Neil Gorsuch is such a phenomenal replacement for Scalia that I think they'll do that. And I think the Democrats know, and then they will lose the ability to use the filibuster even as a threat. So I'm hopeful that they're not going to do the filibuster here. But who knows?
Yeah, the answer is as long as necessary, but not 1 minute longer. I think John's right about Gorsuch. His credentials are really so good. It will be very difficult politically for the Democrats to stop him. They'll try, but they're not going to fight this one for terribly long. And they don't want to force McConnell to pull the nuclear explosion. They will on the next nomination. That's the Donnybrook. That one the Democrats will bleed to the last man to prevent because it means control of the court for the better part of the next generation, which means control of the political agenda, which brings us back to the first question that Scott asked. The court is now in politics up to its eyeballs and was brought to you by the court itself. That's the path down which the court has gone over the past couple of generations. It's the path away from which the Scalias of the world would like to have taken us, and it's the direction which all of us here would like to see the court go. Nominations will become cooler and more rational and less passionate precisely when and only when the court gets itself out of political issues that it really is not constitutionally capable or politically capable of resolving intelligently. If you want to see court fights, you keep the court right into all these issues up to its eyeballs, and you're going to have politically controversial nominations. I think that's bad for the court. I think it's bad for Congress. It's bad for the rule of law. The court has to become much more modest in its pretensions about what the powers of judges are. And until that happens, you're going to have nasty political confrontations.
Are you suggesting no more defining the sweet mysteries of life?
Exactly. Sorry, Ralph, go ahead.
Oh, well, so late in his book, A Matter of Interpretation, Scalia talking about the living Constitution, he called it a morphing Constitution or a kaleidoscopic Constitution constantly changing. And he said, if the Constitution means simply what the people want it to mean, by golly, it will. And the way that that will come to fruition is through the judges who are nominated and through the confirmation process. What he wrote there, of course, we're seeing dramatically illustrated in the past year now.
I can't resist adding a favorite line. If you were Justice Kennedy, not so favorite. It's one of the few occasions when Scalia really got personal in his opinions. It was in the Obergefell case when Justice Kennedy, and even for Kennedy, an unusually vapid expression of sentiment, Scalia quoted back one of the sentences from Kennedy's unfortunate opinion in haec verba, and he says, if I ever wrote a sentence like that, I'd put a bag over my head.
Okay, I think we have a, oh, did you, sorry?
I've got to tell just one quick little...
We can do this all night.
One quick little Scalia thing about Kennedy. There was a case called Rapanos against the United States, which had to deal with the Clean Water Act and the navigable waters of the United States. Of course, it wasn't a navigable water at all. It was a puddle in somebody's backyard that the Army Corps of Engineers was going after Rapanos for having disturbed. And Scalia thought he had a majority opinion put together to clearly restrict the Army Corps of Engineers and its reach in affecting private owners of property. And at the end, Kennedy went soft and concurred only in the judgment and provided no guidance at all for future landowners as to when they could challenge legitimately overreach by the Army Corps of Engineers. And I was in Scalia's chambers, and he said, have you read Rapanos? And I said, I haven't yet. And he got on the phone and called the secretary and said, bring in a copy of Rapanos. And he read it to me, and what he read was a footnote. He was criticizing Kennedy for having things just hanging out there. And the footnote said that Kennedy's opinion reminded him of the story of an ancient Hindu priest who was explaining to an acolyte the nature of the universe and how the world rested on the back of a giant elephant, which rested on the back of a giant lion, which rested on the back of a giant turtle. And the acolyte said, well, what's the turtle stand on? And nonplussed, the priest regained his composure and said, oh, from then on it's turtles all the way down.
Okay, I think we have a question over here.
Would you say that some of the egalitarian and Enlightenment principles in the Constitution almost inevitably make a society turn into a secular one, and then almost through attrition would a less virtuous society therefore make the Constitution completely irrelevant?
How much time do you have?
Well, first of all, I'd push back on your premise. I don't think the Constitution is egalitarian. It's devoted to liberty and freedom instead. Egalitarianism is different from equality. The equality that one finds in the Declaration of Independence is an equality of our equal humanity, which includes the equal right to pursue happiness, to pursue occupations, but unfettered by government except when necessary or absolutely necessary. And that necessarily is going to produce inequality in outcomes. Madison talks about this in his essay on property. And if you're going to have liberty, you're going to have inequality. And I think the Constitution is more a liberty document than an egalitarian document. But you're right, it's been transformed with an egalitarian, almost a French egalitarian purpose with the predictable consequences, not yet quite as severe as the French experience, but we're getting close to that.
Okay.
Let that sink in for a minute.
Great. Okay, I think there's a question here. Jonathan.
I just want to say thank you so much to all three of you. It's awesome. So all three of you touched on Scalia's separation of powers. Maybe this is an ideological question, but is it possible for Scalia's vision of the powers to be separated in the way the Constitution aligns? Is that actually possible in today's society? And if it is, what's the first step the court needs to take to separate itself from the rest of the two branches?
Well, the answer is yeah, they are separable. The difficulty in our time, largely, is the rise of the administrative state, which deliberately fudges the lines among the branches, in which you have agencies exercising judicial, executive, and legislative functions. The court, in a removal power case in the 1930s, unfortunately gave an apostolic benediction to that practice, which has grown like Topsy ever since. And it's very messy, to put it mildly. I mean, I alluded earlier to this Mastretta case involving the U.S. Sentencing Commission. This was a child of Congress created by a political conflict between the right and the left. The right wanted judges to be more severe in the sentences they were handing out. The left didn't want to trust the executive branch in writing the rules now that the Republicans were in office. And so they created the Sentencing Commission, which has a few judges, a few legislators on it, and I think some executive branch officials, and the partridge in a pear tree. And they're authorized by this statute to make sentencing rules that would give judges a fair amount of discretion, not this much, but this much. And it's a political compromise, and everybody on the court sort of knew this. And Blackman for the court says, well, you can't do government any other way in this day and age, and an undue respect for the separation of powers will get us in trouble. This is how we legislate in the modern world, and that's what gave birth to Scalia's humorous remark about the JV Congress. That problem is multiplied endlessly in the modern administrative state, and it confuses judges, it confuses people who teach in law schools, it confuses undergraduates, it confuses people who teach elsewhere than the law schools. One of the lovely things Scalia did, and he wasn't alone in this, but he's the real leader of the pack on this on the court, was to remind everybody there is such a thing as separation of powers, and the court needed to get into the business of disciplining the executive branch and the legislative branch as to how to do this. And that's still possible. I think it's indeed highly likely. One of the things John alluded to in passing about the Scalia's change, apparent beginning to change on the degree of discretion granted by the administrative state to the executive branch in controlling delegates of congressional power. That change has also affected at least three other members of the court fairly significantly. The Chief Justice is very concerned about this in a long passage in an FCC case 2 or 3 terms ago. He said, we're now living in a world that's quite different from the New Deal era when this administrative law system was created. We need to take a hard look at this because of the arbitrariness of the rules that are being enacted here, and we need to readdress the separation of powers issue. Judge Gorsuch, who I think will become Justice Gorsuch, has done much the same thing at the Court of Appeals level. Justice Thomas has alluded to this in a number of cases, that Railway Commission case in particular. Justice Alito has made similar noises along this line. If Gorsuch gets on the court, you're going to have 4.5 approaching 5 votes to reassess substantial parts of the administrative estate and the mess it has made of the separation of powers. And if that's so, in the course of doing so, the first set of opinions they're going to start consulting, other than those of James Madison, which is not a bad start, will be those of Antonin Scalia. I'm modestly hopeful on that front. I really am.
But the question also has an assumption packed into it that I think we need to look at, which is modern society has grown so complex, there's no way Congress can pass laws on everything we need regulations of. And therefore, you've got to have these experts in the administrative state to do this stuff for us. Now, there are 2 things wrong with that. That means we're running this system without any political accountability at all. This was a modern invention of the progressive movement that's designed to remove the people from the equation and therefore remove governing ourselves from the equation. And the second thing that's wrong with the assumption, and I'm not criticizing you for the assumption, it is pervasive out there, is the notion that we've got to have some bureaucrat in Washington that, one, is going to be able to regulate everything we do, and 2, that's going to get it better than we ourselves will get it. And both of the sides of that assumption are deeply flawed. I mean, if the Soviet Union's collapse didn't prove the fallacy that we can run an economy and a system of 300+ million people from the central core, then I don't know what will. And yet what's underlying that claim is the belief in that old assumption that we can regulate these things by experts, and that, you know, whether I have a chair that has a soft back or a hard back is something some bureaucrat in Washington at OSHA should be telling me in my home office, right? Well, if it's bad on my back, then I know how to go get a different chair. I don't need some bureaucrat telling me which ones I should have. And I think this pushback, again, it's the Liberty Constitution. This pushback is underway. Part of the Trump phenomena, I think, reflects that. We'll see whether he carries it out with the intellectual depth that we need to push back and hold it or not. But that's kind of the fight against this administrative state.
If I could just say a word too on the kind of case that might be the first to provide for a challenge is the part of Dodd-Franks that gives us the Consumer Financial Protection Board, where not only is it using executive, legislative, and judicial powers all internally, the very definition of tyranny, of course, according to the Federalist, but it actually doesn't even go to Congress to get its budget. It gets its funding from the Fed. Right. And there is just so much that's constitutionally suspect about this particular board.
Suspect's giving it too much credit. It's just patently unconstitutional.
Okay, well, it might be the perfect initial vehicle, and if they could take that down, that could open the door.
I call you and raise you. In the ACA, the Obamacare statute, there's a provision not yet fully implemented. It was alluded to by Sarah Palin as the so-called death panel. It's the Physicians Advisory, remember, John? It's the expert panel within HHS that basically sets medical prices and allocates medical services. If you look carefully at this provision, it hasn't been fully implemented, thank God. Its decisions are not reviewable by the Secretary of HHS. Its decisions are not reviewable by the President of the United States. And even more astoundingly, on the face of the statute, they would not be reviewable in any court of the United States. I've never seen anything like this in my life. Even with a liberal court, this doesn't have a snowball's prayer. If we could get that thing implemented, I'll bring the case. And let John argue it.
Okay, one last quick question. Peter, you wanted to ask?
Yeah, I was just wondering, when did the Constitution begin to not apply just to the federal government, but also the states? And do you think this is a good thing or a bad thing?
Yeah, so, I mean, this was one of the most interesting fights in ratification of the Constitution, that the Constitution didn't have a Bill of Rights at all. I mean, that's not quite true. You look at Article 1, Section 9 and Article 1, Section 10, there are some protections both against the federal government and against states governments there. But they viewed the structure of the Constitution as providing a more solid security for our liberties. And that parchment barriers, which is what they called the Bill of Rights, wouldn't do much if you didn't have that structure in place. Now, the original Bill of Rights only applies to the federal government because it was limiting the powers of the federal government. The states all had their own Bill of Rights, and they were separate sovereign entities within their own spheres. That proved to be very successful, except in one little minor issue, slavery, that produced a civil war and a restructuring of the relationship of the federal government that at least on certain guarantees that were so fundamental, we wouldn't rely on the states to protect even their own citizens. We would rely on the federal government. And so that transformation as a result of the Civil War, you get the 13th Amendment, but most importantly, the 14th Amendment and the 15th Amendments that kind of make that transformation. And it was aimed at that core problem. But now it's been expanded upon massively, and the largest growth of that occurs in the 1960s, in the Warren Court era, where now the federal government is becoming the protector of everything, rights or no rights, what we call rights, what we make up as rights, what you feel ought to be rights. All of that's now protected in the hands of the judiciary, and so the combination of the fix of the Civil War amendments, but then the massive expansion of them is what has put us in the state we're in.
So the application of the Bill of Rights to apply to the states through the due process clause, through substantive due process. There was, in 1833, there was a case called Barron against Baltimore, where Barron had a wharf in Baltimore, and as a result of dredging of the harbor, it silted up in front of his wharf, rendering his property valueless, unusable. And so there was no provision under the Maryland Constitution or laws that provided him relief, but he saw in the Fifth Amendment that no private property shall be taken for public use without just compensation. And so he sues under the Fifth Amendment. And John Marshall, for a unanimous court, says, no, the Bill of Rights applies against the federal government only, not the states. And there's a line in there that had it been the intention of the drafters of the Bill of Rights that they apply to the states, they would have expressed that intention in clear and unambiguous terms. Boy, you know, the drafters of the 14th Amendment knew about Barron against Baltimore, and they sure as heck didn't speak in clear and unambiguous terms in terms of, does the due process clause mean that the Bill of Rights provisions apply to the states?
But they did give us clearly that whatever the 14th Amendment did applied to the states. No state shall, that's the clear and unambiguous. Then no state shall do what, or prevented from doing what. That's like fair game.
Okay, I lied. I got one last question. A quick 30-second poll. We know that and the subject of tonight was to talk about Antonin Scalia and his legacy and the implications of his death and the vacancy on the court. Quick 30-second poll. Who do you think is next to retire from the court?
I'm guessing Ginsberg or Kennedy. We hear different stories about either. And it'll be one of those two, unless somebody else has an unanticipated heart attack.
Yeah, Kennedy hadn't hired clerks for next term yet, which is a pretty good sign he was intending to retire in June. Yep. And then when the word got out around that speculation, he all of a sudden started interviewing clerks. So now he may just be doing a feint there. One never knows.
Maybe a head
I think he won't do it. Kennedy's the author of several of the war on terrorism cases. I know I'm past my 30 seconds, but I think this is important to understand. Kennedy's the author of several of the war on terrorism cases, in which, in my view, the court illegitimately intruded on powers the executive clearly has directly under the Constitution. And he did it because he thought if he didn't do that, the executive would be unchecked in the war powers. And that we can't have in the modern world. And I think he probably carries over a similar view of Donald Trump. And until he sees Trump not acting as the media has portrayed him, as a tyrant and not ignoring the law, I don't think Kennedy's going to step down.
Professor?
Yeah, on which subject, by the way, Trump did himself no favors by speaking so pejoratively as he did about that judge in Seattle who issued the injunction, is a foolish statement, but Trump never should have said, in the language he said it about that judge. The judiciary, both liberals and conservatives, justifiably took umbrage at that. And in the context that John was describing it, that's the kind of thing that would get Kennedy's viscera up. So Trump needs to watch his tongue. Yeah.
Well, both the Seattle judge and the Ninth Circuit obviously felt that they could declare that the Constitution applies internationally and other things based on the Kennedy Guantanamo Bay decisions.
Yep.
But what Trump should have said is not called him a so-called judge. He said this judge has issued a so-called opinion.
Right.
And that's, because
There's 100 ways he could
the opinion is lawless. It doesn't even cite the relevant statute or the relevant Supreme Court precedent. And so he was on solid ground in criticizing it, but not in the terms that he did it.
Yeah. Well, gentlemen, this has been a real treat, and I've been telling my students all day and bribing them with extra credit, perhaps even. But these men are teachers of teachers. You heard the pedigrees that Dr. Wright elucidated about these men. These are not ordinary folks that have come across our midst, and we've been blessed tonight to hear from them. So thank you, gentlemen, and one last note of appreciation from the Biola community.
Biola University prepares Christians to think biblically about everything, from science to business to education and the arts. Learn more at biola.edu.